So how do the ultra wealthy legally hide their money from creditors? I am the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. And if you've ever wondered how to keep your assets safe from creditors the legal way, you're in the right place. Spoiler, it's not about hiding, it's about protecting. So stick around and I'll give you the straight facts, real stories, and stats to prove what works. Like no-nonsense advice? Hit subscribe if you haven't, and let's dive in. Let's start with the obvious. When you lose a lawsuit in the US, your first instinct might be to hide your money. Maybe you're thinking, I'll give it to mama, or I'll stuff it in a Swiss bank account like a movie villain. Well, here's the harsh truth. Hiding assets doesn't work. It's like trying to hide a pizza from a room full of teenagers. Somebody's going to sniff it out. Once a creditor wins a judgment against you, they've got a legal toolkit that'd make Sherlock Holmes jealous. They can file something called a motion for examination of judgment debtor. That's a fancy way of saying they'll drag you into court and put you under oath and ask, where's your stuff? And here's the kicker. You have to tell the truth. Lie, and you're looking at contempt of court. Think fines and jail time, not exactly the vacation you had in mind. Take cryptocurrency, for example. People think it's the ultimate hideout because it's anonymous. Wrong. Most crypto sits on exchange accounts that look like regular investment portfolios. A creditor can spot those in a heartbeat during an exam. Plus, the blockchain, it's a permanent record of every transaction. The second you buy Bitcoin, there's a digital breadcrumb trail leading right to you. And with AI, creditors can track this down faster than a hound dog on a raccoon. Stats back this up. According to a 2023 report from Chainalysis, over 90% of crypto transactions are easily traced with the right tools. I mean, so much for hiding. Now, here's a real story. I once had a client, let's call him Dave, who thought he'd outsmart the creditors by transferring his yacht over to his cousin's name. He did this after losing a lawsuit, and guess what? The creditor hired an asset search company, found the paper trail, and then the court ruled it a fraudulent transfer. Dave lost the yacht, paid a hefty fine, and worse, drug his cousin into the lawsuit. They actually sued his cousin. They'd sue your mama. They'd sue your sister. They sue anybody who you try to transfer assets to fraudulently. So hiding is a delay tactic and not a defense. It's like putting your house key under one of those fake rocks by the front door. Sure, it might fool a casual burglar for 5 minutes, but anybody who knows what they're doing will walk out with your favorite computer by lunchtime. So how do creditors actually find those assets? Let's break it down. First, there's a motion for examination of judgment debtor we talked about. They sit you down and ask you everything, your bank accounts, your real estate, cars, stocks, even that coin collection you've had since college. They'll ask about future money, like insurance payouts or that big commission that you've been expecting. And you're under oath, so no fibbing. But here's a pro tip. You don't have to volunteer anything they don't ask about. If they forget to ask about your secret stash of vintage comic books, well, that's their problem. But it doesn't stop there. See, this is a big part of their training in law school, how to pry every bit of information they can out of you to get into your pockets. And creditors have backup plans. One is asset protection search companies. And these are like financial bounty hunters. They'll dig through bank records, property deeds, even your social media, because posting that new Ferrari on Instagram isn't as sneaky as you think. 2, public records. Ever bought a house or registered a car? Well, that's all public info and creditors can see it. Number 3, forensic accountants. These folks are like the ninjas of finance. They'll comb through your tax returns, credit reports, and bank statements to find every penny. A 2022 study by the American Bankruptcy Institute found that creditors recover assets in over 70% of judgment cases when they use these tools. Hiding? Good luck. Let me tell you about a case that I saw several years ago. A guy, let's call him Mike, lost a $2 million judgment. He thought he was slick, like moving cash around to an offshore bank with no trust structure. The creditor hired a forensic accountant who traced the wire transfers through 3 countries in under a week. Mike's hidden money was gone, and he was out the legal fees too. Moral to the story, creditors don't mess around. Okay, so hiding's a bust. What's the alternative? Protection. That's the alternative. Instead of playing hide and seek with your money, build a fortress around it. Now, there are a few ways to do this: domestic trusts, business structures, retirement accounts. But after 34 years in the field, I can tell you one method that stands head and shoulders above the rest, and that's offshore trusts, specifically Cook Islands trusts. Now, Cook Islands are part of New Zealand and south of Hawaii, and at Asset Protection Planners, we've set up more Cook Islands trusts than anybody in the world, and they work like a charm. Okay, so why protection over hiding? Simple. Hiding assumes you can outsmart everyone forever. Protection assumes they'll find your assets and make sure they can't touch them. And that's the difference between hoping a bully doesn't notice your lunch money and locking it in a safe they can't crack. So let's dive into how these offshore trusts work, because that's where the magic happens. Now, here's the nuts and bolts. An offshore asset protection trust legally separates you from your assets. You don't own them anymore, your trust does. And if you don't own them, creditors can't take them. Sounds pretty wild, right? But it's 100% legal and incredibly effective. The key player here is the trustee company, a licensed bonded law firm that we appoint in a place like the Cook Islands, Belize in Central America, or Nevis in the Caribbean. So you transfer your assets into the trust, and the trustee manages them according to your trust deed, which spells out exactly what happens to your money. So wondering about the safety of this, trustworthiness? Stick with me, we'll talk about that. Now, here's where Asset Protection Planners takes it up a notch. We don't just stop at the trust, we put a Cook Islands LLC inside the trust, and that's what holds your bank account. And then we make you the signature on the account. Why? Because it gives you control over your assets on the day-to-day. Think bank accounts, investments, and real estate would combine with other legal tools or whatever you've got. But when a legal storm hits, like a creditor coming after you, our licensed bonded trustee company steps in as LLC manager. They take the wheel, and your assets stay locked away, safe from attack. And safety? Cook Islands is the most regulated trust jurisdiction in the world, with a crystal clean reputation. And then once the dust settles, you're back in charge. It's like having a financial bodyguard who knows exactly when to step in. So take Sarah, a client of ours. She's a stock market and real estate investor who got sued over a property deal gone south. Before the lawsuit, we set her up with a Cook Islands LLC with an LLC holding her assets. We structured her real estate with land trusts, LLCs, and equity stripping liens. And then when the creditor won a $1.5 million judgment, they came knocking. Our trustee company law firm stepped in as manager of the LLC inside the trust, and the creditor hit a brick wall. Sarah kept her stock and properties, and the creditor walked away empty-handed. That's the power of this structure. In fact, I have a Cook Islands trust for myself and my family as well. Now, stats back up this protection too. The Cook Islands has enforced its trust laws for over 35 years, and not a single U.S. judgment has pierced one of our Cook Islands trusts. That's a 100% success rate. Why? Because the Cook Islands courts don't care what a U.S. judge says. It's not their jurisdiction. So let's go ahead and paint a picture. You've lost a lawsuit, the creditor got a judgment, and they're ready to raid your bank account. You're cool as a cucumber. Why? Because your assets are in a Cook Islands trust with a Cook Islands LLC inside of it, set up by Asset Protection Planners, of course. The creditor finds out about it during the debtor's exam. Good for them. And when they try to collect, they realize they're stuck. The Cook Islands doesn't recognize U.S. judgments. Your trustee company doesn't have to hand over a dime. If they're stubborn and sue in the Cook Islands, which we've never seen with any of our clients, it gets even better. They've got to prove fraudulent conveyance beyond a reasonable doubt. That's a criminal standard, not the maybe standard of civil court. Plus, they've got 1 to 2 years from the transfer to file, and they need to hire a local attorney in the Cook Islands who won't work for free. They don't work on a contingency fee basis. Oh, and they'll need to drop a cash deposit, think $100,000 or more, just to start the case. If they lose, they pay your legal fees too. A 2021 analysis of Cook Islands cases showed that creditors abandoned over 85% of claims before trial because the odds are so bad. They see the trust and think, nah, I'm out. Compare that to a domestic trust. I had a client try a US-based trust once before he came to us. After losing a lawsuit, the creditor claimed fraudulent conveyance, and the court agreed. The trust was toast in 6 months. So offshore is where the real protection lives. Now, we do set up domestic trust too if a client insists. But why do we at Asset Protection Planners swear by the Cook Islands? It's not because of the beaches, though they're nice. It's the laws. For nearly 30 years, I've been setting up trusts there because they're built to protect you. Their International Trust Act of 1984 is a fortress of legislation. In fact, creditors need to prove intent to defraud beyond a reasonable doubt, as we said, and that statute of limitations is tight, 1 to 2 years from the transfer, not the judgment. Plus, foreign judgments, they don't mean squat there. So here's a fun fact for you. The Cook Islands has a population of about 17,000, smaller than most U.S. colleges, but its trust laws are so robust that it's a global leader in asset protection. In fact, our firm has set up thousands of these trusts, more than anybody else, because we know they work. We've seen them shield doctors from malpractice suits, entrepreneurs from business flops, even divorcees from ex-spouses, many times. Now, one client, a surgeon, faced a $3 million malpractice claim, and his Cook Islands trust held firm, and he kept his life savings. So that's not luck, that's planning. So what's the takeaway? Don't hide your assets, protect them. So here's how to get started. Step number 1, set up an offshore trust before your suit. Timing matters. Do it after a judgment, it can still work, but it's riskier and more costly. Step number 2, work with pros who've done this thousands of times, like us at Asset Protection Planners. We'll craft a Cook Islands trust with an LLC inside, tailored to your needs. Step number 3, live your life knowing your wealth is safe. It's simple. Need proof it's worth it? A 2020 study by the Global Wealth Protection Institute found that people with offshore trusts saved an average of 92% of their assets from creditors, mainly because they can settle for pennies on the dollar, compared to just 15% for those without. That's not pocket change, that's your future. Let's wrap this up with one more story. Meet Tom, a tech founder who sold his startup for 10 million bucks and then got sued by a competitor claiming intellectual property theft. Before the sale, we set up his Cook Islands trust. When the $4 million judgment hit, his trust held his cash, stocks, and even his vacation home. The creditor tried everything. Debtor's exam, threats, even threatened a Cook Islands lawsuit, but never did. They gave up after 6 months, out $50,000 in fees. So Tom's now sipping that coconut drink today, and his creditors are still fuming. That's the difference between hiding and protecting. So there you have it, folks. Hiding assets is a losing battle, but protecting them with the Cook Islands Trust is a legal slam dunk. This is the business guy, the CEO of the Lawyers Limited Law Firm and Asset Protection Planners. I spent 34 years helping people like you keep their wealth safe. So if you want to learn more, go ahead and head over to assetprotectionplanners.com for more free information. And if you want, you can schedule a consultation with my team. And if you like this deep dive, smash the like button, hit subscribe if you haven't, ring the bell so that you don't miss out on our next video. We're here every week with real talk about protecting what's yours. So tell me in the comments, what's your biggest asset protection question? I'll see you in the next one. This is the Business Guy.